Please be seated. We'll hear argument in 2639, Nettye Engler Energy against Bluestone Natural Resources.
May it please the court. Mr. Pennington will present argument for the petitioner. Petitioner has reserved 8 minutes for rebuttal.
Morning. May it please the Honorable Supreme Court of the State of Texas. My name is Alan Pennington, and I'm here representing Nettye Engler Energy. This case involves the interpretation of a non-participating royalty interest reserved in the 1986 deed, which conveyed surface and reserved some minerals. The grantor who reserved the royalty, my client is a successor of the grantor who reserved the royalty. The question for the trial court is, what is the meaning of the phrase "free of cost in the pipeline, if any, otherwise free of cost in the mouth of the well"? There were cross motions for summary judgment filed in this case, and the trial court, Judge McCoy, granted Engler's motion for summary judgment, finding that that particular reservation was free of certain post-production costs. Judge then had a second hearing in which she determined which post-production costs were exempt from the royalty, were exempt for that particular royalty interest. She noted that in the deed, in the 1986 deed, 2 different valuation points were expressly envisioned. She also noted, if you'll see the exhibit, that there is an otherwise language, a disjunctive word, which she held determined that valuation could not be at the mouth of the well because of the existence of a pipeline. In granting Engler's motion for summary judgment, the trial court relied on the expert testimony of Patrick Murphy, who I contend is the top oil and gas attorney in Tarrant County, who stated that in the 1986 deed, the term pipeline meant the transporter pipeline, not the gathering system, as was being urged by Bluestone. Patrick Murphy's testimony was not contested by any summary judgment evidence. Any objections to his statements in a 3-page affidavit that he filed in support of our motion for summary judgment were waived. The reason I say they were waived was because there were only vague objections made to his 3-page affidavit. Those objections were expressly overruled by the court. And at that point, in addition, there was no summary judgment evidence whatsoever offered by Bluestone on the meaning of the term pipeline in this reservation. So the case went up to the Court of Appeals. The Court of Appeals expressly agreed that the phrase "free of cost in the pipeline, otherwise free of cost at the mouth of the well" had to be interpreted and harmonized. In other words, she agreed with both parties that language had to be interpreted and considered. She also, the Court of Appeals also agreed in its opinion that the deed specified 2 different valuation points, 2 separate points. And I would note that in the response brief on the full briefing in this court, Bluestone does finally admit, and I don't believe they had before, that the 1986 deed specifies 2 different valuation points. But the Court of Appeals, after recognizing that it had to consider all the language and that there were 2 different valuation points, it determined that the valuation was to be at the mouth of the well, despite the fact that all parties agree that there is a major pipeline from which the gas from these 34 wells goes. And I believe, if reading the Court of Appeals opinion, that the emphasis of the Court of Appeals was a reliance on the Burlington decision from this court. The Court of Appeals basically said, never mind the 2 valuation points. Burlington says if you have language in a deed that says "free of cost in the pipeline," Burlington prophylactically says that means that you value the gas at the mouth of the well. In doing so, the Court of Appeals ignored the 2 valuation points and basically said that the gathering system and the pipeline are really the same thing, that they're synonymous. After the Court of Appeals decision was rendered, Bluestone appealed, I should point out that in the Court of Appeals reversal, in the original brief of the Bluestone, there was no mention at all of Mr. Murphy's opinion on which the trial court based her opinion. They didn't challenge Mr. Murphy's statement, his opinion that the word pipeline refers to the pipeline, the major pipeline, the transporter pipeline, not to the gathering system as contended by Bluestone. And there was no point of order raised on that at all. In addition, and more alarming, was the Court of Appeals did not even mention Mr. Murphy's statement and his opinion. So there was no point of error raised. The word Murphy does not appear in the appellant's brief filed in the Court of Appeals, and it also doesn't appear in the Court of Appeals opinion. So I believe the real question before this court boils down to what is meant by the term pipeline in the phrase free of cost in the pipeline, otherwise free of cost at the mouth of the well.
And there are two, right? Two pipelines. Two pipelines.
There are two major pipelines.
And whichever one it is, the royalty's different.
Whichever one it is, whichever one it is, our position is it's free of cost till it gets to that pipeline. That was also Mr. Murphy's position. Now, that was not a legal opinion that he supplied. He basically saying, and he's been practicing law as long as I have, since 1981. He's been an oil and gas lawyer for all that time. He's board certified. He says in his affidavit, at the time this 1986 deed was executed, that pipeline did not refer to the gathering system. It referred to the pipeline.
Would pipeline refer, though, to a third-party pipeline that the lessee doesn't have any control over? In other words, is it a fair inference to say that pipeline means any pipeline, including, envision a whole series of pipelines before the gas is sold, owned by various entities? Would it be a fair inference to say that a third-party pipeline is the pipeline that's being defined in the 1986 deed?
Perhaps, Justice Bland, perhaps that issue could have been raised by summary judgment, but I'm pointing out that there was no summary judgment evidence offered to contradict Mr. Murphy's statement of what that term meant in 1986. And so it's Bluestone's position that refers to their gathering system, which is on the lease, and it was our position, and we're the only ones that supported it with summary judgment evidence, that in 1986 that would refer to the pipeline, the major pipeline that goes, I suppose, to the Gulf of Mexico. And as Justice Hecht points out, there are two of those. Okay? So it's not a question, along those lines, it's not a question, Justices, about whether the gathering system consists of pipes. I mean, we all know there's no way to move gas except through pipes or conduits of some kind. The question is, what did that phrase mean in the 1986 deed?
And on that, so if we agree that pipeline could be any pipeline, the deed says in the pipeline, does that really give us a valuation point? Because in the pipeline could be at the very moment it's turned over to the transporter, it's in the pipeline. But then it also could mean the very moment it's, at the Gulf of Mexico being offloaded.
That's exactly right.
So does in the pipeline really help us decide at what point to value the gas?
Well, I guess Judge McCoy's made it easy for you because she said that we have to start paying the post-production costs at the moment it enters the transporter pipeline. So whether the valuation point and sales price is determined at that point or downstream of the pipeline, she ruled that we have to pay those post-production costs, and we don't challenge that on this appeal. As I said, the Court of Appeals opinion relies exclusively on On the Burlington decision, as you know, this court in the Randall case shortly after, also involving Bluestone, said specifically that that case is not a trump card, I think were the words used for in the pipeline, meaning valuation at the mouth of the well. And the court also said in Randall and in Burlington that you have to look at what the parties meant at the time they executed that deed. What did the parties intend? And I believe it's clear that the parties intended that if there was a pipeline, and again, everybody agrees there's a pipeline, we just disagree what it is and where it is, but there is a pipeline, and so that negates, the otherwise language expressly negates valuation at the mouth of the well.
But it seems a little unlikely that the parties would say free of cost in the pipeline, if any, if there was a pipeline sitting out there.
Well, this was done in 1986, and these wells were drilled during the Barnett Shale era, so there would have been no pipeline at that time, I don't believe, Your Honor.
But was the Energy Trust pipeline there at the time?
I don't know, that wasn't developed in summary judgment record.
The gathering system was not there.
Sir?
The gathering system was not there.
The gathering system came along, I believe, after 2010 as well, okay? And there is an emphasis throughout the respondent's brief on the merits on the long distance between the mouth of the well and where the transporter, the main pipeline, starts. There is no summary judgment record as to how far that is. It may be, it could be anywhere from 500 feet to who knows. But I would submit that emphasis in the brief is intended to tie into a lot of these cases that they cite where they talk about far downstream from the wells. We don't know how far it is from the wells to the pipeline, the major pipeline. There's no summary judgment evidence of that. So we believe that the situation, I would add quickly that Williams and Myers, which is an authority, of course, on oil and gas, in their 1984 edition, they specifically describe pipeline and gathering system with two different definitions. And they say that the gathering system is the pumps, auxiliary tanks, and other equipment used to move oil and gas from the well site to the main pipeline. So in 1984, that's 2 years before this deed was signed, the Williams and Myers oil and gas terms are saying those are two different instrumentalities. I see that my time is up. Thank you very much.
Any other questions? Thank you, Mr. Pennington. We'll hear from the respondent.
May it please the court, Mr. Clinton will present argument for the respondent.
But before I get into my presentation, I do want to say, may it please the court, that it's important to point out a couple of falsities, just outright falsities in what you just heard. It is outright false that Patrick Murphy's testimony was the only expert testimony in the record. Professor Pam Burney also was an expert testimony in the record. There were dueling experts telling the trial court what the meaning of the deed was. Specifically, the court can go to page 394 and 395 of the record, where Professor Burney was specifically asked about the meaning of the word pipeline and whether a gathering pipeline counts as a pipeline. And she said it has no matter, that it is the first time it enters a pipeline. So that is outright false, that it's the only testimony in the record. There were dueling expert opinions. Mr. Murphy himself also contradicted himself, because his initial testimony. So what happened here is he had a deposition. In his deposition, he said, it doesn't matter. I don't give any meaning to the words pipeline. It doesn't matter which pipeline it is. It could be a big pipeline, could be a little pipeline. His testimony that contradicts the stance that later came in his affidavit is on pages 331 and 332 of the record. And so he actually controverted his own testimony.
Is the meaning of this a fact question?
No.
So
it doesn't matter.
Do we just look at this expert testimony as legal briefing, basically? I mean, it doesn't make any difference, does it?
Absolutely, that's correct. It doesn't matter. We have dueling experts telling the court what these words mean. Those are not fact. That is not a fact. Those are legal conclusions. And legal conclusions...
Unless it's ambiguous.
If the court determines that, yes, if the court determines that the wording itself is ambiguous, then we can start bringing in all of this stuff. Of course, then it couldn't be decided on summary judgment, I guess. The whole thing would be sent back. But it's not ambiguous because we know what a pipeline is. And we don't look to expert testimony to tell us that something is ambiguous.
So how do we know that a gathering system, which is not just pipes, but also pumps and tanks and the other things that go along with that, is a pipeline?
Well,
how do we know that as a legal matter with no ambiguity?
Well, we know it's a pipeline because it meets the definition of the word pipeline. The initial pipe that it goes into on the lease is a pipeline. It's a gathering pipeline. And it's also false that Williams and Myers didn't consider this a pipeline. And Williams and Myers specifically says that includes within the definition of pipeline within the definition of pipeline, a gathering pipeline. And then if you go down the road and look up what the definition of a gathering line is, it says that it's a subterranean natural gas pipeline. So the word pipeline is not ambiguous. And we only by learning this, that this law expert tells us something differently, that's the only thing that creates an ambiguity. But in Barrow Shaver,
except that the deed uses the mouth of the well and in the pipeline as two different things. And so why doesn't that reading just change the deed to say free of cost at the mouth of the well, period, full stop?
because there's a difference between them. I mean, we can see there is a physical distance depending on the substance. There can be a physical distance between the wellhead and the pipeline.
Even if there's pipe in between those 2 points?
Well,
A line of pipe between the well and the gathering system?
there can be a distance between the place where it enters the first, as Justice Bland said, the first place that it starts putting it in a pipeline to move it off the lease. And that's essentially, I mean, Burlington is very, very similar. Burlington had a royalty clause that moved it slightly adjacent to the wellhead and slightly away from the wellhead. And that was at the tanks, receptacles, and in the pipelines. The way that for oil, the way that an oil works is that you have to take it to a tank first because you have to remove the water. Gas comes off the top, water comes off the bottom. You have to remove the water, and then you can put it into a pipeline for transportation off the lease. The way that gas works ordinarily is that it can go straight into a pipeline. So, and as I think the Texoga brief well pointed out, this was oil, gas, and other minerals. So in the instance of other minerals, it wouldn't even go into a pipeline at all. If it's coal, if it's uranium, it wouldn't go into a pipeline at all.
Well, that's why it says or mine, so I assume that takes care of that part of it.
Well, if there is a pipeline, that's where we start. If there is not a pipeline, we go to the well or mine. So the primary choice of the parties to this initial instrument was we'd like it to go into a pipeline if there is one. If there isn't, then we take it.
Well, but there's going to be a pipeline.
Well, that of course.
The only question is, are you going to measure it before processing or after processing?
There's not always going to be a pipeline because in the case of coal, there wouldn't be a pipeline, right? This is oil, gas, or other minerals.
Well, but if it's gas.
That's right. In gas, it's going to be done by pipeline. In oil, it might not always be done by pipeline. It might be trucked, as in several of the cases that are cited. What these parties were doing, where they were saying, look, we have a pipeline preference. We wanted to put in the pipeline. That is, especially in the case of oil. Remember, we didn't know what the minerals were going to be because this deed was authored and executed in 1986 prior to this being a developed area. So we didn't know what minerals were going to come. But what we'd like you to do is put it into the pipeline if there is one. And that pipeline is near the well, just as exactly what this court said in Burlington, that those words in the pipeline mean at or near the well. But I think it's also...
You're agreeing, it sounds like, that if somehow factually the pipeline were a distance away and there was a lot of processing in between the well and the pipeline, that those costs would not, under this reading, those costs would not be charged to the royalty holder?
Well, precisely. I mean, and that's the case of oil. The oil has to be processed on site before you can put it into a pipeline for transportation off of the lease. So in the case of oil, you have some processing. You have to take the water out of it. So there are tanks, and this is, again, what you were writing about in Burlington.
I'm just clarifying, you're not equating into the pipeline with at the well in all cases.
Not at all. In fact, we're not equating them at all. We're saying that if there's a pipeline, it has to go in the pipeline. If there's not one, it's an at-the-well delivery. Now, I do think this is critical, because I think one more falsity. The plaintiff told you that the Court of Appeals has specifically read out in the pipeline, and the Court of Appeals says, no, we say that if there's a pipeline, it goes into the pipeline. If there's not a pipeline, it's at the well. So the Court of Appeals did understand that they were two different places. The key to this case, I think, is reading the plain language of the instrument itself. And the plain language of the instrument itself is not even contemplating valuation, because these parties did not have a monetary royalty. They had an in-kind royalty. If you have an in-kind royalty, you haven't even fathomed that there would be two different valuation points, because the only thing that you've fathomed is that there's going to be an in-kind delivery. So we can look at the words itself. Grantor, its heirs, this is on page 60 of the record. Grantors, its heirs, successors, and assigns own, meaning that they thought they actually owned it, and previously they had said this was carved out of in and under. So this was an odd instrument. But they said they actually owned the stuff. Own and shall receive and be entitled to receive a free 1/8 of gross production of any such oil, gas, or other minerals said amount to be delivered to grantor's credit free of cost in the pipeline, if any, otherwise free of cost at the mouth of the well. As Justice Hecht wrote in Hyder, those words, gross production, are an in-kind royalty. And this court has said it many times before in Hager versus Stakes in 1927, and Felber versus Sklar, which is a writ refused case from Texarkana in 1950. The court has said when you use this in the pipeline language, you're really talking about an in-kind delivery. You are delivering the stuff itself. And what these parties agreed to is if you deliver the stuff into a pipeline, that we are preferring it to be delivered into the pipeline, if any. Now, I think Justice Hecht's point is really good. The question that you asked about, was there a bigger pipeline at the time? Was there a transfer pipeline? Of course there were transfer pipelines in Texas somewhere at the time. So the parties couldn't have meant if there's a large transportation pipeline somewhere, because those pipelines had existed for 100 years in Texas. The parties could only have meant if there's a connection on the lease, to a pipeline connection on the lease. That's the only thing that hadn't yet been decided in 1986, was whether there were going to be gathering pipelines on this lease itself. And here we do have gathering pipelines on the lease itself. And so we put the stuff, the actual gross production, which is what these parties wanted, not a monetary royalty, but the actual stuff, we put it in the ground for the first time on the lease. I think, Justice Bland, your question about what if we had multiple series, I mean, we don't know what the industry is going to do in the future. Back in the 1920s, it would have been one pipeline company that picked it up at the wellhead and brought it to wherever the ultimate consumer would have been. In the 1980s, it's possible, we understand that their expert says that at that point, that the producers had owned the original pipelines that took it later at some connection. Now that's not even true. Now we know, as is the status here, that the producers don't even use gathering pipelines now. Usually that too is a wholly different company that picks up the gas and takes it off of the lease. Same thing with oil. They're not horizontally integrated, these companies. So generally, the oil gets processed at site and then taken off of the lease by a third company who purchase it. Now,
so if it were the case in 1986 that the producers traditionally owned the gathering system, does that affect how we should interpret the word pipeline?
It doesn't, because a pipeline is a series of tubes that transport gas.
So it doesn't matter whether it's first party or third party owned?
It doesn't matter at all. And the courts who have looked at that question too have reached the same conclusion, that it doesn't matter at all who owns it. What matters is it is a tube to transport oil or gas off of the lease. The moment it is in one of those tubes that is intended to transport the oil or gas off the lease, that's the entrance to the pipeline. And this is really important too. The issue here, the core issue, and I think we all agree now, as Justice Hecht pointed out, we all agree that the issue is where's the entrance to the pipeline. We all agree that it's free of cost to the entrance of the pipeline. We all agree that the royalty owner bears its proportionate share of the cost after it enters the pipeline. So the only question before the court is, where's the entrance to the pipeline? This is important. Every authority of every kind who has ever talked about this in writings has concluded that in the pipeline is the pipeline on the lease, the pipeline on the ground on the lease. Every single authority cited in both parties' briefs that construes the words in the pipeline in every jurisdiction says that the word pipeline is the pipeline on the ground on the lease. There's not a single authority cited in either brief that says otherwise.
Unless it's oil. You said if it's oil and it goes through a pipe and then it goes to a tank, that's not a pipeline.
What I've said is that the first time that it goes into a pipeline for transportation purposes to take it off the lease, that's what every single authority has understood the words in the pipeline to mean. There are some cases that bring it earlier. I mean, I guess you're right. There are some cases that collapse into the pipeline and say that it's the moment that it goes from the wellhead to the pipeline, even with oil. There are no cases that take it downstream. So the only disagreement in the cases is whether there is any difference between a pipeline and at the well. That's the only the argument in the cases. There are no cases cited in any party's brief that take it downstream, that say that the pipelines on the ground on the lease are not a pipeline. Not a single one. We've cited authority from this court, of course, in Burlington. The court said so. The court said that in the pipeline is a proxy for at or near the wellhead. The court didn't say at. It doesn't necessarily always be at, but it's at or near, which is, of course, the truth when you take oil or gas and you stuff them in the ground in a pipeline. It's going to be near the wellhead. It may be at, as Justice Busby pointed out, but it will always be near, unless you truck it somewhere else. It's possible that you'd have to truck it somewhere else if you didn't have a gathering system, and you still wanted to get it to a gathering system, you might have to truck it. But every authority of every kind, there's not a single cited authority. This is why plaintiff has to falsely try to convince you that the record is undisputed as to what this means. That is not true. The record is not undisputed. Plaintiff's expert himself disputes the opinion. See, what happened here is plaintiffs initially took the position that the valuation point was at the point of sale at the ultimate consumer. And then changed it, that's what the plaintiff's expert first testified to in his deposition. That what I believe, he said, he actually testifies, I'm telling the court what this means. And what it means is all the way at the ultimate consumer. But plaintiff, in the interim, after the summary judgment briefing, changed its position, after the motion for summary judgment, I should say, changed its position and said, we changed our mind. What we now believe is that it's at this arbitrary point at which the gas changes custody between pipeline companies. And so then the expert comes back and files an affidavit, again, after the motion for summary judgment was filed, and says, I still believe that I'm right, that it's the ultimate consumer, but if I'm wrong, it means plaintiff's new theory. So his primary position, their expert's primary position, isn't even what their argument is today. That was his alternative position that he came up with after plaintiffs changed their own view of what this deed meant.
What's your view of the role of the expert testimony here? I mean, it seems like it could be one of three things. If there were an ambiguity, it could be used to try to answer the question of what this meant. I understand your position that there's not. If it could also just be treated as legal briefing or like a treatise, that says here's what it means. And then, there are some cases that say, well, you can look at sort of what is the relevant understanding of this in the community and that sort of thing in order to, if it has a specialized meaning in a relevant industry or something like that. Is that what's going on with the expert testimony here, or is it just like legal briefing?
Well, I mean, I honestly think it's not even legal briefing because this was purported to be evidence. And this court has said time and time again that legal conclusions are not evidence. So it doesn't transform into evidence because it made it into the appellate record. It's still no evidence. No evidence that's 5 years old is still no evidence, right?
But But is it evidence, do you view it as, I mean, you offered it too, so I'm wondering for what purpose?
Well,
If you offered it as evidence, do you think it's evidence of the meaning of, in the relevant community, a specialized meaning, or what is its role?
Well, I would say we only offered it because they designated an expert. So, it's one of those things, well, if the court's going to let it in, we better have one too. Not because we truly believed that it was evidence, but because if the court's going to let it in, we better controvert it, right? Which is the thing they're claiming we didn't, but we did. With respect to answering your second question, this court has said we don't look to expert evidence to define the meaning of something unless we believe it's ambiguous. And so we have to ask the ambiguity question first before we get to the expert testimony.
But in some circumstances, we do look at contextual information to decide whether something is ambiguous. And so I'm wondering if your view is, does this fall in the bucket where we can do that or we can't, and why?
Well, this court said in Barrow-Shaver that industry custom is only admissible for the jury. It said when consideration of evidence as to industry custom and usage is appropriate is a question of fact for the jury and is the province of the jury to weigh witness credibility. So we don't introduce evidence of industry custom unless we've already determined that it is ambiguous. And in that case, it can't be determined on summary judgment anyway. So this would never be appropriate evidence to attach to a summary judgment, because only if it's a fact question, only if it's ambiguous and therefore a fact question, would we look to it to determine. So the question then, I guess at the end of that is it ambiguous? Because we know that all the precedent, all the regulations, all the statutes, all the CLE presentations, all the law reviews, all the treatises, everything says that in the pipeline is at the entrance to the pipeline on the lease. So is there some ambiguity despite the uniform conclusion of every analysis of this? No, because there's no ambiguity as to what the word pipeline means. And I would go to the very definitions of pipelines. The Webster's definition of pipeline is a pipeline is a line with pumps, valves, and control devices for conveying liquids, gases, or finely divided solids. So the ordinary definition outside of the oil and gas industry is a tube that stuff goes through. Williams and Myers defines a pipeline as a tube or system of tubes for the transportation of oil or gas. So Williams and Myers, the industry definition, is the same. There is no definition of pipeline. There is literally no definition of pipeline, of the word pipeline, that would exclude the pipeline on the lease. There is no definition. So the only way you could possibly conclude that it's ambiguous is to have an expert tell you that it's ambiguous. But we can't consider expert testimony to determine that something's ambiguous. That's what Barrow-Shaver says. So outside of expert testimony, if we simply look to the ordinary definitions, both outside and within the industry, in the pipeline means the tube on the ground on the lease.
I guess I'm still having trouble understanding how under the Webster definition of a tube that stuff goes through, the mouth of the well wouldn't also be the pipeline location even in an oil situation.
It's possible to pick up the oil in trucks at the wellhead. It's also possible, and also in the case of other minerals like uranium or coal, it would never go into a pipeline.
Any other questions? Thank you, Mr. Clinton.
Thank you.
Mr. Pennington, you have 8 minutes.
Thank you, Your Honor. At the time that Patrick Murphy's deposition was taken, Bluestone had not taken the position that the gathering line was a pipeline. They had previously taken the position that since they were not affiliated with the gathering system company, that they could charge. So everything changed after these depositions were taken. After Mr. Murphy tendered his affidavit, there was no request to take his deposition. And the only statement that we were relying on in his affidavit in this court today, the only statement is not a legal conclusion at all. It is his statement that based on his experience that in 1986, pipeline meant the main pipeline, the transporter pipeline. Now, I have not seen or heard of this reference to Professor Burney's statement. I'll have to look at that back at the office because I've never seen that cited or used in response to the motion for summary judgment we filed in the trial court. But I do know that when I took her deposition, this wasn't even an issue. This is a gathering pipeline, a gathering system of pipeline. It also was not an issue when Mr. Murphy's deposition was taken. But how do they get to this point? What do they have to do to get to this point to say that they can call the gathering system a pipeline? What they say is, if you look closely, they're saying, okay, there's two valuation points, but Bluestone may incur costs between the wells and the gathering system, but it doesn't charge for those. So what Bluestone is telling this court is that they can manipulate the valuation of our gas, our 1/8 of the gas, back to the mouth of the well simply by not charging Engler these costs that it incurs between the mouth of the well and the gathering system. And of course, going along with that, they have to come up with a new name. And the new name that they've come up with for their gathering pipeline in their motion for summary judgment that they filed when they changed the whole stature of the case was it's now called a gathering pipeline. So that's what you're faced with. As far as the definitions in Williams and Myers, I stand by what I said. The reference that counsel made to oil pipelines, including gathering lines, specifically is related only to oil pipelines. Separately, following that, Williams and Myers define, say in the case of gas, the gathering system delivers the gas to the main pipeline. And then I already gave you their definition of gathering system that takes it to the main pipeline. So I want to talk about Mr. Murphy's opinion, the only one we rely on, which is not a legal opinion. Basically, we are not relying on his testimony early on that he said that this was entirely cost-free. We abandoned that. And the court held what she held, that we're free of cost up until it gets to the pipeline. We say that's the main pipeline. Again, there was no objection made to Mr. Murphy's statements except these global objections. There's 3 global objections to a 3-page affidavit. Those were overruled.
Counsel, what's your position on this question of what is the court supposed to do with expert testimony about the meaning of a contract when neither party is contending that the contract is ambiguous?
I was just getting to that, and the answer is that this court has said many times that Justice Busby points out that if there is a technical term in a contract or a deed or so forth, that expert testimony, if that's what this is, and I think Mr. Murphy's statement is more in the way of fact, but it can be relied upon. And I'll give you several examples. This court's case 2007, Exxon versus Emerald Oil. They took an expert definition of the term drilled and completed with regard to an unambiguous contract. Tittiser versus Union Gas. This court, Texas 2005, allowed testimony as to the meaning of the word pooling and what was recognized as an unambiguous contract.
I guess my question, does it make a difference that this is testimony, or would it be of equal value if you just put a citation in your brief to a CLE presentation or some other place where this guy had said these things?
I believe, Justice, that it's not an opinion at all. It's not a legal opinion. He's not expressing a legal opinion that as to what the effect of the main pipeline being referred to as the pipeline in the industry. That's not a legal opinion, and so he is simply testifying essentially as a fact witness with expertise as a board certified oil and gas attorney as to this is what is meant. And I'll mention a couple of other cases. The Barrow Shaver case, which counsel just mentioned.
If he's an expert, would it be a factual opinion? Is that, if it's not a legal opinion, but he's testifying as an expert?
It's a factual opinion, sure.
He's saying, this is my understanding from...
No, he's saying that in 1986 when this deed was executed, pipeline didn't mean gathering system. And I don't think pipeline means gathering system now. I think if you send a guy out and say, You need to go work on the pipeline. He's not going to go to the gathering system. And so the Barrow Shaver case was mentioned. That's a case from this court 2 years ago. And the court in that case says that industry custom and usage absolutely may inform the court of the meaning of industry-specific words. These are not exact quotes. Custom and usage is often involved to shed light on the meaning of oil and gas-related contract provisions such as those found in leases, farm-outs, and operating agreements. And they could have added oil and gas deeds if they'd wanted to. And so you cannot use this type of testimony by an expert to alter or add to a document, but you can certainly use it, as this court has said 3 times in the last few years, to inform you as to what a specific industry term means. And that's exactly what Mr. Murphy did. And because they did not object at all and even mention Mr. Murphy's statement that the court relied on until their reply brief in the Court of Appeals, Rule 38.3 of the Texas Rules of Appellate Procedure says that point is waived. So that's what you have at this point. You have, I believe, because this was not an issue when Professor Burney's deposition was taken, I think all you have is Mr. Murphy's statement that in 1986, pipeline didn't mean the gathering system. And I've demonstrated how they have to manipulate their calculations and so forth to even claim that it is. So in summary, this court said in Burlington that we have to look at what the parties meant when they executed this deed, and that's what Judge McCoy did. What the Court of Appeals ruled, in effect, is to say, they rewrote the deed to say, I want to read this right, that the phrase free of cost in the pipeline, if any, free of cost at the mouth of the well, really means free of cost at the mouth of the well if there's a pipeline, otherwise free of cost at the mouth of the well. The Court of Appeals ignored the 2 valuation points and held that it's still, no matter what we say, it's still at the pipeline because of Burlington. So we would ask the court to reinstate the trial court's grant of summary judgment in favor of Nettye Engler Energy. I very much appreciate the attention and the questions of the court. It's an honor to be here.
Any other questions? Thank you, Mr. Pennington. The case is submitted, and the court will take a brief recess.
All rise.